Hello everyone, this is Compass, navigating legal studies for your mission. This video is for a legal essay practice. Today's topic is joinder of parties. Problem. Tech Innovators LLC, a limited liability company organized in State X with its principal place of business in State X, has two members, Chloe, a domiciliary of State X, and Daniel, a domiciliary of State Y. Chloe serves as the manager member of the LLC. Tech Innovators entered into a written software development contract with Codemasters Incorporation, a statewide corporation with its principal place of business in statewide. Codemasters agreed to design and implement a software system for tech innovators. Fin Corporation, a financial institution incorporated in State X and with its principal place of business in State X, agreed to lend tech innovators up to $1 million to fund the software project. FinCorp disbursed $200,000 to Codemasters as a down payment for the contract. The loan agreement between Tech Innovators and FinCorp stated that all funds disbursed would be added to Tech Innovators' loan balance to be repaid with interest over a 5-year term. As the project progressed, FinCorp continued disbursing payments to Codemasters as required. However, when the software was completed and delivered, FinCorp refused to release the final $50,000 payment, claiming that the software failed to meet specifications. Tech Innovators has also withheld its final payment to Codemasters. Codemasters filed suit against FinCorp in Federal District Court in State X, invoking diversity jurisdiction. Codemasters alleges that FinCorp's refusal to release the final payment violates the loan agreement with Tech Innovators, claiming it is a third-party beneficiary of the agreement entitled to $50,000. FinCorp has moved to dismiss, arguing that Tech Innovators is a required party to the action and has not been joined. Questions. 1. Does Tech Innovators qualify as a party that must be joined, if possible, in the Codemasters versus FinCorp case? 2. Would adding Tech Innovators as a party eliminate the court's subject matter jurisdiction? 3. If Tech Innovators cannot be added as a party, what should the court decide regarding the motion to dismiss? 1. At issue is whether Tech Innovators is a required party. A party is required to be joined if feasible when, first, complete relief cannot be accorded among the existing parties without the absent party, or second, the absent party claims an interest in the subject matter of the action, and their absence would impair or impede their ability to protect that interest, or leave an existing party at risk of incurring inconsistent obligations. Here, Tech Innovators is a party to the loan agreement at the center of the dispute. Complete relief may not be granted without Tech Innovators because the agreement involves obligations between Tech Innovators and FinCorp. And Codemaster's claim hinges on its status as a third-party beneficiary of that agreement. Additionally, Tech Innovators has a significant interest in the case as a determination regarding FinCorp's payment obligations under the agreement could impair its rights or obligations under the same contract. Therefore, Tech Innovators is a required party under Rule 19A. 2. At issue is whether adding Tech Innovators would destroy diversity jurisdiction. Diversity jurisdiction requires complete diversity of citizenship between plaintiffs and defendants. In case involving an LLC, the LLC's citizenship is determined by the citizenship of all its members. Here, Tech Innovators is an LLC with two members, Chloe, a domiciliary of state X, and Daniel, a domiciliary of state Y. Codemasters, the plaintiff, is a corporation domiciled in state Y. Joinder of Tech Innovators would therefore destroy diversity jurisdiction, as one of its members, Daniel, shares citizenship with Codemasters in state Y. Therefore, Joinder of Tech Innovators would deprive the court of subject matter jurisdiction. 3. At issue is whether the action should proceed without Tech Innovators. If a required party cannot be joined, the court is directed to determine whether the action should proceed in their absence or be dismissed. Factors include, first, the potential prejudice to the absent party or existing parties. Second, whether any prejudice can be mitigated. Third, whether a judgment rendered in their absence would be adequate. And four, whether the plaintiff would have an adequate remedy if the action is dismissed. Here, Tech Innovators' absence could prejudice FinCorp, as FinCorp may face inconsistent obligations if Codemasters and Tech Innovators bring separate claims regarding the loan agreement, while the court could mitigate some prejudice through protective provisions. A judgment without Tech Innovators might not fully resolve the dispute. Codemasters could file a suit in state court, preserving an alternative remedy. Therefore, the court should grant the motion to dismiss, as the absence of Tech Innovators would result in significant prejudice and the lack of complete resolution. Let's wrap up this session by revisiting the key rules. A party is considered required to be joined, if feasible, if the court cannot provide complete relief among the existing parties without the party's presence, or if the absent party claims an interest in the subject matter of the action that might be impaired or impeded by their absence. Additionally, if the absent party's absence could expose an existing party to inconsistent obligations, the absent party is deemed necessary. If joinder of the required party would destroy subject matter jurisdiction, such as by defeating diversity jurisdiction in federal court, the court must determine whether the action can proceed in equity and good conscience. This analysis considers factors like the prejudice to all parties involved, the adequacy of judgment rendered in the party's absence, and whether an alternative forum is available. Thank you for watching. See you in the next video. God bless you.